and a plea for help.
But I want that statement in there.
Yeah.
I want the jury to hear that he said he was gonna kill me.
Yeah, I mean, you want the statement in.
Right.
I mean, depending on, what kind of case, in a criminal case, and, because the issue is intent, I'm assuming he's charged with attempted murder, then you probably have a better shot of keeping it out under that theory. But yes, you could do that in a criminal case, what you hear, I heard screams, without telling me what the screams were, or what they said, based on those screams, what you did. But just imagine, even in a criminal case, well, I heard screams and I heard Monica say this. Whoa, right? So if you can lay the foundation that it's not being offered to show John's intent, that he was trying to kill Monica, you could arguably get it in. But then the probative value versus prejudicial effect analysis gets in. So, the relevance is going to be questionable because it definitely is prejudicial, extremely prejudicial. But I mean, your goal is to get it in because that's a damaging statement either way, right? Yes.
Do you make those prejudicial probative arguments in front of the jury, or is that something that you would want to do outside of the presence of the jury?
Well, it depends. Well, I mean, you have to object. I mean, here's how it goes. It goes, Judge, witness A, officer so and so. When you went into the house, you went up to the house. Yes. What'd you hear? I heard Monica scream, "Objection, Your Honor, hearsay." Right? The other side stands up. He doesn't want it in. Judge, that's hearsay, and can we approach the bench to discuss it? Well, no, counsel, I'm not. Not on the hearsay, Judge. I'm not going to let you approach the bench. Well, Judge, I don't think that it's admissible because it's they're offering for the truth of the matter. Okay. Now, let's say you're in front of you're in front of the jury. And the jury's listening to all this take place, the back and forth between the lawyers, and then they say, well, Judge, we're not offering it for the truth of the matter. We're just offering it for the effect that it had on the officer. All right? So it's not hearsay. And then you're saying, well, Judge, look, my objection is hearsay, but if they're trying to argue it's not hearsay, then what's the relevance of it? And I think that is extremely prejudicial to me. So I'd like to approach outside the presence of the jury. Now, if you don't do that, and what I tell my folks are, which works, and you will see in real life, is if you don't move to approach, well, let me tell you why it's relevant, Judge. Boom! Right? He was trying to kill her, and he said this, right? Right? So, quietly, get in front of the judge, because that's what happens. And you watch, and as long as you guys understand that potentially could happen, that's good. A sharp lawyer will say, okay, want me to respond to relevance? Okay, I'm getting my whole theory out in front of the jury. I'm walking right in front of them. Let me tell you, Judge, why it's relevant. All right, so make sure that even in these mock trial competitions, that you move constructively to approach the bench. Justin.
What is the basis of, okay, so say you're on the opposing side and someone objects, and they say, it's mine, I'm proffering it, and so they say, Judge, well, what's the relevance? And we approach, and they give relevance. What is the argument, to use 403 to counter that argument? I mean, if they're like, well, what's the if I'm not offering for the truth of the matter asserted, they're like, okay, well, then what's the relevance? And the relevance is, A, because he wanted to kill her, and yada, 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 yada. And so if I want to counteract that, what do you use 403 to come up with an argument for that, or what is your response to their relevance?
Well, what they're saying is, Judge, it's not relevant. So your response is break down the relevancy objection. Judge, in order to be relevant, it has to substantially outweigh, probative value has to be substantially outweighed by the prejudicial effect. And it has probative value here, Your Honor. And the fact that it comes in, either it doesn't hurt them much, it doesn't substantially outweigh its probative value to me. Or you just have to go through the analysis under 403.
Because I guess in my head, the statement, he's gonna kill me, that could be pretty prejudiced. So
Yeah.
what is my argument that its probative value substantially outweighs that? What argument do I have? Because if I'm not offering for the truth, then what do I argue is the probative value of it?
Well, that's what you have to lay the foundation for. So, if we have this as a civil case, Well, Judge, he's being sued for invasion of privacy.
Okay.
So it's probative as to his thinking about why he went into the house.
So you relate it to whatever the suit basis is.
Yeah, I mean, number one, I mean, that's obviously that, but maybe it goes to, I don't know, credibility or something. You have to have some argument that is probative to some issue,
Okay.
and that it's not, that the prejudice doesn't overcome that, and then the test being substantially overcomes it. It may overcome it, but it has to substantially overcome it. That's the rule.
Substantially overcome the prejudicial value?
Yeah, the probative value, right, correct. I think the rule is the probative value has to be substantially outweighed by the prejudicial effect of that coming in. So your argument could be, Judge, look, it may be 51-49 what I lose, but that doesn't equal substantially. So it should come in. I mean, the point is you're trying to get it in, all right? And if you go to the 403 analysis, you can argue, I always ask, my participants, okay, well, what's the prejudice to you? And how does that substantially outweighed by the probative value to the offering party? Because that's the analysis you have to go through. So if you're the plaintiff, if you're the one offering a statement, that's what you have to think of, and if you're the one trying to keep the statement out, that's what you have to think of also. Okay? So that's an interesting kind of analysis, but I mean, you kind of see how it goes. I mean, your job is to get it in, depending on what side you're on, or keep it out. So at least you know the analysis. Tobias?
Can you object to, Your Honor, that question calls for hearsay? To get it, try to nip it in the bud before they even get it out?
Yeah, but only if they ask a hearsay question. Officer so-and-so, when you went to the door, did you hear somebody say something? I mean, you know it's coming, because he's got to relate what someone else said. Yes, I did. Objection, hearsay. Call for hearsay answer, Your Honor. So you can object before you even answer. But, I mean, a smart lawyer's going to say, Officer so-and-so, did you go to the house? Yeah. Did you hear something? Yeah. What'd you hear? Then it's kind of like, what'd you hear doesn't mean it's hearsay. And then he's blurting in, you can see it coming, right? But he had to hear it from someone else. Okay, just a point of why he's offering. Okay? All right, let's see. I think that's the answer. It's not hearsay. The second trial, however, the issue is not whether John tried to kill Monica, but rather whether the officer entry into the home was lawful. Here, the statement's not being offered to prove that John tried to kill Monica, but it is instead being offered to prove that the officer had probable cause to enter the home. Whether John was actually trying to kill Monica is irrelevant to the issue at hand. What matters is whether the officer believed that Monica was in danger and whether it had been necessary to kick the door down to further investigate. All right. I mean, we kind of discussed everything. All right, example number 4. Witness's own statement as hearsay. Suppose a person is testifying on the stand, and this is what we were talking about earlier, in relation to it. Now, suppose the witness is testifying on the stand, all right? And in relation to an automobile accident where a blue truck struck a yellow, I pulled this off of some sheet, where a blue truck struck a yellow car, witness testifies, I told a police officer the truck was blue to establish the color of the car. He's offered for the truth of the matter, that the car was blue, as opposed to whether he had lied to the police or the officer moved up. Statement is an out-of-court statement offered for the purpose of proving the truth of the matter asserted, and that is what color the car was. The witness is testifying about what someone said in the past, that person being himself, okay? Which is a little-known fact. I mean, people kind of let that blow by themselves, but I mean, I remember thinking to myself, wow, can it be a hearsay statement if that person made the statement out of court? I started going through the analysis and I'm thinking, I guess it could be. It just seems weird, it just seems odd, but it is. So if it's something that you don't want, but it's real narrow, and most judges, sometimes allow that to slip more than a lot of the other stuff. If the declarant is testifying to a fact of a statement that he made out of court, and it's offered for the truth of the matter, you can object to that as hearsay also. Strange, but true. All right. All right. Okay, statements which are not hearsay. Prior statements of a witness, which is, I think, is what a lot of us were just talking about earlier. And 801D kind of goes through those, Federal Rules of Evidence 801D, as to what these are absolutely not hearsay. So we're talking like depositions, all right, like you can impeach with depositions, all right, they're not hearsay, all right, you can impeach them with a deposition. And it kind of, I just copied the rule, prior statement's not hearsay, the person who made the statement, the declarant, is currently testifying and is subject to cross-examination at the current trial, hearing, proceeding, deposition, and the prior statement is inconsistent with the declarant's testimony at the current hearing. And the prior statement is given under oath at a prior trial, hearing, proceeding, deposition. This is straight from the rule. I don't want to, you guys can read the rule, but the point is, for you guys' purposes, and in every one of these fact patterns, they always have them. They have like a deposition that somebody said something inconsistent to what they say at trial. All right, and although I haven't heard anybody object to hearsay yet, I guess everybody's kind of accepting of it. The question is, can you get in the deposition that the person testified about, at least the statement portion of it? So yes, because that's not hearsay. It's just a prior inconsistent statement. Okay, as long as it was under oath, like a deposition or a hearing. I think you were talking about like a former trial. Now the question is, can you get in a statement given to a police officer in a report? Let's say you have an accident, you talk to a police officer, said the exact same thing. Can you get into that? And I'm going to let Josh deal with impeachment, but it's just relevant here because you certainly can impeach him about it. You just can't get it in evidence. You can ask him, well, and so, you have to lay the foundation. On such and such a date, you spoke to this police officer, right? Yes, I did. He came to the scene. Yes. You hadn't talked to a lawyer before that? No. You hadn't decided to sue anybody prior to that time? No, I did not. And you were trying to give truthful information? Yes. Complete information? Yes. Accurate information? That's correct. And at that point, you told that officer this, didn't you? I mean, you just can't, if he says no, you gotta just move on. Because you can't get it in evidence. Okay? Because it is hearsay. All right? So that's the foundation for laying impeachment. All right. Now I know time is of the essence here for you guys. I know we're doing lunchtime stuff, so I kind of want to. I'm going to skip a little bit here. All right. The other one is not hearsay, admission by a party opponent, which I think Eddie was just talking about a little while ago. If you make a statement, if John made the statement to the officer, and the officer heard that statement that John made, that's an admission by a party opponent. He's trying to kill Monica so they can get that in. Okay, it's not hearsay. All right. Let's see, that's the same thing under 801. All right. Now, state of mind also. It's not hearsay offered to show the state of mind of the hearer, the person who heard the statement. So which is basically the same thing as not offered for the truth of the matter. Same thing we were talking about Ben in the parking lot. If he made a statement and Jessica's on the stand and she said, I heard Ben say this, as long as it's just offered to show what she did based on that, then it's not hearsay. Okay? And the same with the police officer in the other case. Now, they're having this, Jessica brought it to my attention actually, and I kind of had to pay attention to it. And I'll kind of skip to it in a minute, but I'm just flipping through the rules here. All right. Hearsay rule, Federal Rules of 802, hearsay is not admissible. It's not admissible except as provided by these rules or other rules prescribed by the Supreme Court. You have to be aware of Crawford versus Washington. Have you guys studied? Okay, all right. If it's testimonial, then the declarant has to be available. But there is exceptions to that under 802. And under 802, it says hearsay exceptions lists hearsay where statements are not excluded by the hearsay rule, even though the declarant is available as a witness. Present tense impression. I mean, I just listed 8 of them, and there's a ton of them. All right, so, but the emphasis of 803 is that the person who makes the statement, he can be there. He's available, but you don't need him to actually get the statement in. Okay? Now, kind of flip through 804. That's when 804 deals with when they're not available, and there's a list of exceptions you get in when the declarant's not available. And there's I didn't write down the particulars about, I mean, you can just read the rule about what constitutes unavailable. Like if, you know, when I was in Philadelphia, I was the low man on the totem pole in this murder case. And what they did was they kidnapped one of the main witnesses. And this was the act, you know, you hear this some of this like story stuff. This is the mob, it's the actual mob. And you know, you just think, man, this is not real. It's like surreal, but it actually was. They're, you know, Nicky Scarfo. Yeah, you know, it was funny. It was, you know, if I wasn't involved, it would be kind of funny. But you know, it's like The Sopranos sort of, you know. But what they did was they kidnapped one of the main witnesses. Right? So then they were, you know, the lawyers were trying to argue, well, Judge, look, you know, he may be unavailable, but doesn't fall into one of the exceptions. But the trick is, if you cause them to be unavailable, then it still comes in. Okay? So, and there was some evidence that they, you know, they rolled some people who testified, they kidnapped them, et cetera, et cetera. Needless to say, they got convicted. One of the only convictions in the state court ever of the mob. Usually the feds get them. All right, and real quick, now just remember there's a residual exception under 807, right? Which basically says if it's just fair to get it in, Judge, and it's reliable and the trustworthiness has been laid as the foundation, under 807 you can make an argument you should get it in. Rarely do judges allow it in unless it's something that they really want in. But I want you all to be aware of it at least, that, you know, if none of the other things work, you can argue it's under 807 there's a residual exception, and it's got the aura of trustworthiness and credibility, and therefore we should get it in, Judge, no matter what. Make that argument, all right? Because they're trying to keep, the other side's trying to keep it out. All right. Real quick, I kind of wanted to get in just a little bit to this stuff, and it kind of came up this semester, and you know, I kind of take it for granted, but there's a big push on electronically stored information. The acronym is ESI, okay? And Jessica and I were kind of tossing it around, you know, the other day. I kind of take it for granted, but I never really looked into the foundational aspects of it. So, you know, nowadays everything's on email or CD or chat, text messages or chat room type stuff. You know, there's some argument that stuff shouldn't come in, all right? So, you know, if I didn't want it in, I'd argue that it shouldn't come in because it's just hearsay. It's just straight out hearsay. And here's some things that you can argue or look at. Here's some considerations to determine whether or not it comes in or not. All right. There was a case that came out, I didn't write the case name down, but about 10 years ago, this was the thinking of the court. One court wrote, the internet and ESI were patently unreliable, inadmissible, and voodoo. Because they just weren't up to speed on it, right? And now, more than 90% of all documents are produced and stored in computers and never printed. I mean, they're just not. So judges have had to kind of jump through hoops to figure out, okay, how do we keep this in? How do we keep it out? You know what? You know, how do we handle this? Because it is a document, right? It's a document. So subject to the hearsay rules, just like anything else. All right. You have 4 evidentiary hurdles. All right. You have 401, which is relevance. You have 901 and 902, which is authentication. 801 and 802, hearsay and exceptions. And I think somebody brought that up the other day about the 1001 through 1008 and stuff, which was the best evidence argument. All right, but I mean, it's an email. You know, what other best evidence could there be? You'd have to print it out from somebody's computer somewhere. Okay, so you always have that. So, all right. So you guys got the 4? Everybody got the 4 written in? Okay. Those are the things you have to look at. All right. Under relevancy, 401, usually the easiest hurdle to clear. Clearly a lot of it's irrelevant. You get an email that says, hey, Ben sent Jessica an email saying he shot this guy. Well, okay, that's pretty relevant. All right, does the evidence have any tendency to prove or disprove a consequential fact? Clearly, that's a fact and issue in a murder case. So, you know, that would be your argument under relevance. Let's see, all right, under authentication. You want to ensure that the evidence is trustworthy. Is the matter in question what it purports, what its proponent claims it to be? So let's say they then sent an email and it said, you know, on one email it just says, "Hey Jessica, how you doing?" And then on the email they're trying to introduce, it says, "Hey Jessica, how are you doing? I just want you to know I shot Monica." Okay, I mean, but that happens. I mean, these days that can happen. And you can print it out and you would never really know. So you have to, if there's some question about it, and they have all these experts analyzing these emails, see whether or not they're accurate or not, or whether they've been tampered with, but you have to have some evidence of that. All right, so you challenge it based on authenticity. It's not the proper email. And the way you show that is, I guess you have a hearing outside the presence of the jury to show that you received this other email. And this is the one that you, the receiver, have, as opposed to, you know, and you look at the time, you know, they got the times on the headers and all that kind of stuff. All right, you have to link those up. All right. Anyway, that's what I'm talking about. Unscrupulous behavior, damage, contamination, improper search and retrieval techniques, programmer errors, equipment malfunction. That's the reason you could argue that they haven't laid the foundation to get electronic stuff in. All right. 901, under Federal Rules of Evidence 901, sets forth the requirements to authenticate, but it doesn't tell you how to do it. It just provides lists of ways to authenticate using other evidence, so witnesses and things like that. And then you have to look under 902, is it self-authenticating? Okay, is it, and you know, we don't have time to kind of go through the rules, but that's in your problems that you have. Can you make an argument that even if it's not authenticated under 901, we don't have any evidence of that, can we get it in under 902? It's self-authenticating. Okay, now under 901, there's this whole list of things that authenticate documents. Now, what we've done in some of the stuff that we've handled is you get an expert to say, "I've looked at it, I've seen it before, I downloaded it from X, Y, and Z site, it looked exactly like it did on that date." That's kind of self-authenticating depending on the source of the document. All right, if it comes from like a public agency, if it comes from an entity that has a duty to keep records like this, then you could arguably authenticate it through your expert, or through a witness who's actually got familiarity with the exhibit. For instance, we were doing the other day an email, right? A Twitter, Twister account or something like that. And the authentication was that, yes, I wrote it. I got this response, and this is the response, so it hasn't been tampered with, is the point, right? It looks like in the same condition it was when I got it, and then you can see the time it was sent. It was sent to me at my email address. That's my email address. You have to lay the foundation to make sure you get it in. Now, you guys are going to be dealing with all that stuff as you go on. So I want you to know that some of these problems are designed to have you look into the little minute details as to keeping stuff in, or getting stuff in or keeping it out. Now, all you guys are good lawyers, and you're going to be good lawyers. You have to understand that the nuances here are they put it there to see if you can get it in. Okay, and if a lot of people are just not aware of it and just blow it right past it. Okay, we're just not going to object. Or they're going to have some, they haven't gone through the analysis under 901. Okay, Judge, we object. Well, what's the basis of your objection? So my team, quite frankly, I want to be prepared for that. Well, Judge, here's the analysis under 901. If they're objecting under 901, it comes in, we've authenticated, we've laid the foundation through X, Y, and Z witness, and this is what they said. So if they're objecting to improper authentication, I think that we've overcome that. Now, the question is it just straight hearsay or something to that effect? We can deal with that later, but certainly it qualifies as an email received from somebody's account. Okay? All right. let's see, all right, well, here's, should have shown this slide to begin with. All right, here's common ways to authenticate using extrinsic evidence. Testimony of witness with knowledge, which I was talking about with Ben on the Twister account, circumstantial evidence, which are, like, you know, when you download documents from a website, and excuse me, it has on the very top, sometimes the header of where you got it from, you know? Like, let's say you download something from, let's say Jessica has her own website. You download something from her, and has a little header that says Jessica, and then it gives her last name. I cannot avoid calling you the riot, but I can't help it. It's Theriac, right?
Theriac,
Okay,
yeah.
all right. And it has that as a header, and, you know, it has like a, what do you call it, like some kind of protocol address on it. Then, you know, that's circumstantial evidence that it came from her website, okay? Whether it's admissible or not, I don't know, but, you know, but at least you have enough to authenticate that it potentially came from her computer, all right? And that's, yeah, question.
And all of these relate to other documents too, so it's not just, are these solely electronic documents, or these are just all documents in general?
Well, these are solely electronic. I mean, the analysis relates to all documents, but there's a unique situation with electronic documents because you never get the originals. You only get what's on somebody's computer. Like you pull them off the internet, you know, things of that nature. So the question is, you know, are they relevant? You know, number one. Number two, are they authenticated? You know, did you actually get them from that website? Does it actually say that on that website? Because I've seen some unscrupulous people who just, you know, kind of cut and paste the header and stick on what they want to get in. So you just have to be aware of it, and if they can't overcome that hurdle, shut them down. Check. You know, it doesn't come in. Anyway, that's a whole new frontier that you guys are going to have to deal with, and there are plenty of reasons to keep it out. And if your opponents don't know what the reasons are, maybe keep out something that you think would normally be admissible. Keep it out, particularly for these competitions and in real life in general. This is new. This is cutting edge stuff. People have not gotten into how do we get in text messages. People just kind of take it for granted. You know, like you print it out. Here's a copy of the text message. Well, wait a minute. You know, prove up that it came from his phone. You know, you have the phone. You have to link it up to the carrier. At this time, was that message sent? You know, do you have a copy? You know, let me see. Let me look on the other person's phone, the recipient's phone, kind of prove up. So you know what to ask for at subpoenas. Okay, you know, I don't want to get too far into it, but I want you to be aware that is a major. It hasn't been settled yet. You still fight to keep a lot of this stuff out. All right, and I just bring it up because it came up, and I got to tell you, just personally, you know, we get every now and then I get a website that has some, you know, innocuous thing that I wanted evidence, and I just mark it and offer it, and I've had no objections to it whatsoever because it doesn't really say a whole lot. It's kind of like a newspaper, you know. I'm not offering for the truth of the matter, just the fact that it was printed. Okay, we had a trial a couple years ago in the City Hall case in Dallas, and I offered Mayor Miller's criticism in the in some article, just for the fact that it was in there versus the truth of what it said. No objection. Okay? So I thought I'd get a fight on it. Just allowed it in. I was like, okay. But now, you know, when you get this stuff, fight. If it hurts you, fight to keep it out. But these are the ways, those four things are the ways to keep it out. But they have to show you in a pretrial hearing that stuff's admissible. Authenticated, it's relevant, it is what it purports to be, and it's not hearsay. All right, and it's best evidence. Now, best evidence, how do you have best evidence with a computer print? You have stuff on the internet, right? It's out there in cyberspace somewhere. Let's say you just print it from your computer and offer it here. And the objection is best evidence, Your Honor. You know, there's no indication that is what it purports to be, and we need the original. Well, hey, there is no original. It's on the computer somewhere. Somebody scanned it from some agency. All right, so you have to deal with that. Let me see if I and I'm gonna let you guys go here in a minute, but, so, you know, I think what the only way to kind of get around it is, you have to have a witness to testify to it. Like, we have a fact pattern in our case about something from the CDC, right, but it was on the computer. So we have some arguments